forces dictate how, throughout history, technological market power has risen and fallen. And if we look at the most recent and probably, if you want, radical economist research, I'll point you in the end slide with the further reading references to Mordecai Kurtz. He's a US economist who's detailed how there is direct causal link between lawful ownership of proprietary technology, proprietary that bestows exclusionary rights, meaning I can use it and you can't unless you pay me a license fee. So ownership of proprietary technology, causal link, direct causal link with rising economic inequality, both personal and functional. So this economist simply stated, says, when we see technological upheaval and rapid innovation, on the one hand, and on the other, we have passive antitrust policies, what we see is innovators with a small competitive advantage being then allowed to become unassailable monopolies. He says there's a direct causal link. And in the absence of public policy, technological market power or technological monopoly leads to the emergence of a few dominant firms. And he computes, he does the sums. I won't bore you with it, but he details, there's a shopping list of effects: lower investments, lower consumption, lower gross national product, slower rate of growth of an economy, slower rate of adoption and use of new innovation by the public, extreme inequality of income and wealth, sharp decline of a middle class, deepened social discord, weaker foundation of democratic institutions. And you say, boom, this is surely exaggerated. Well, I can refer you to the book. You can draw your own conclusions. It's a very, very persuasive argument. The point is that if we don't take antitrust policy seriously, what we're left with is what we have today: hyperscalers that dominate and make markets unassailable. So we have seen this before. It's called the First Gilded Age. It was the turn of the 20th century, end of the 19th century, beginning of the 20th. We had new general purpose technologies such as steam engine, electricity, and innovation there allowed a few monopolists to extract excess profit from the markets. Think of General Electrics. That first Gilded Age was then followed just after the war, in the post-war years. Let's look at the US because it matters. Post-war years leading up to the mid-80s, roughly, the Reagan period. In contrast, that was an experiment, a true experiment of egalitarian distribution that today is hard to get our head around. Just to give you a few figures. In 1942, during the war, the marginal income tax rate was set at 94% on any income over $200,000. 94%. It was lowered after the war, but then it was raised back in 1951 to 91%. And it remained at the level until 1963. And right up to 1981, the marginal income tax rate stayed higher than 70%. It was only during the Reagan administration in 1986 that the US Tax Reform Act cut the top rate to 28%. Now, this is just one side, one element of the policy equation, of course. What was interesting in the period between the end of the Second World War and the Reagan years is that taxation policy was supported by very, very strong antitrust policy with strict merger controls. So although antitrust is not the only solution, it certainly is a key part of the solution. So let's have a look at what's happening today and then. The legal foundation of a traditional antitrust law and practice are still not suitable for addressing the problems created by technological monopoly. If you want, the first Gilded Age is a story of failure, a story of antitrust failure. At the turn of the 20th century, those key tenets of traditional antitrust law failed to restrict General Electric's monopoly. Essentially, it was impossible to nail them. The administration gave up. In plain terms, it made very obvious the extent to which patent laws are in conflict with antitrust laws, and the extent to which the policy goal of having a perfectly competitive economy is in conflict with the thinking that says that innovation should be rewarded with market power. Firms that innovate should automatically be awarded market power, technological monopoly. These need rethinking. Today, the digital landscape very closely resembles the first Gilded Age, and some talk of today's landscape as the second Gilded Age. I don't have to tell you that today's digital markets see a few hyperscalers extracting monopoly profits from the markets they're serving. And monopoly profit is actually a technical term. An economist will define that as any profit above and beyond the normal rate of return on investment. Now, these IT winners have been supported by the laissez-faire passive policies of the 80s Reagan administration, and the rise of inequality since the 80s is documented by economic and social studies. As discussed, that rising inequality was avoidable. So the overview, it's dispiriting, but the exciting thing is that the conversation is changing. And the more exciting thing is that all of the sort of intellectualizing, all the philosophizing has now turned into actual laws that a regulator can wave at firms and implement. So today's digital monopolies have got a new legal basis. We can contain digital technology market power or technology monopoly and still preserve the incentive to innovate. And this is why I'm actually very, very excited to see what's happening next with the Competition and Markets Authority. So I'll take a little sip of a glug of water. Tell me if I'm boring you, or if there are any questions, I'll take them now. Otherwise, I'll crack on. Okay, so as briefly mentioned, but we'll
hello, Sarah.
Yes.
Someone just asked, just checking, are we still on slide 1?
Yes, stay on that slide. Stay on that slide. Yes.
Okay, someone just requested that. Okay, that's fine.
Yeah, I'll tell you when we move on.
Okay.
So, what went wrong? In traditional antitrust thinking, the key test to assess if a market is functioning properly or not is whether consumers are harmed by prices kept artificially high. That's pretty much the key test. To the extent that prices are kept low for consumers, traditional antitrust thinking does not see a market issue. Traditional antitrust probes would not pay attention to those that today we know are the key strategies to consolidate that initial first mover advantage into technological monopoly and deter challengers from entering the same market for goods and services. We know what these strategies are. We've got names for them. We can list them. We know how to go about and hunting them down. So we talked about patent pyramids, patenting layers of related innovations. We know that one of the key strategies is building obsolescence or products that require ongoing updates. We know that another strategy is acquiring challengers before they become even noticeable. So it's called, we've got a name for it, isn't it? It's the kill zone. It's when we acquire everything that has even the remotest possibility of challenging the incumbents. Is the strategy of purchasing all the challengers' patents as soon as possible. It's the strategy of impeding supply of talented workers with the so-called non-compete clauses that last way over a year after you've left an employer, for example. Reputation creation strategies, perfectly legal. Customer loyalty programs, perfectly legal. Interesting, accumulating information about customers and suppliers that is not available to the public and that is not shared with suppliers or customers themselves. Technological standard settings, a strategy. Establishing banking relationship, securing prime business locations. All of this is legal. But in traditional antitrust thinking, market power or technological monopoly was seen as transient, as something that will not last forever, and also seen as necessary, as a sort of cost to pay to innovators. In traditional thinking, we believe that challenger firms would then push markets back to a state where many firms are all much smaller and all in perfect competition. But we know empirical evidence has told us that technological market power does not follow that pattern. Technological market power is different. Technological monopoly is not eroded over time, is durable, and market entry becomes increasingly harder with time. So, CMA, enter the CMA. New powers. These have been bestowed by the Digital Markets, Competition and Consumers Act of 2024. It was passed in the previous legislature, so before the elections, but it made it in the new legislature, so it's now law. Amends and integrates the Enterprise Act of 2002. And the new powers are an evolution of the existing duty of the authority. The Competition and Markets Authority has always had the duty to promote competition for the benefit of consumers, on the assumption that when markets work well, firms compete to win business through offering better value for money and for products and services, and by developing new products in response to customer demand. The process of competition is also thought to encourage innovations and ensure a great range of choice. So the CMA will not obviously shout from the roofs that it's now become a radical egalitarian policy sort of paladin. It will do what it has always done, but there are subtle differences in what it can now focus on. So firstly, the CMA can conduct market reviews, market studies, or market investigations to ascertain if markets are not working well. The new powers establish a so-called forward-looking regime. A forward-looking regime is where the CMA is expecting to assess whether or not a conduct in a market by a firm is likely to lead to future adverse effects on competition. So instead of measuring adverse effect once they've happened, the new regime gives the CMA the power to try and second guess where the markets are likely to go and where competition is likely to suffer. And they have the power to impose remedies before any adverse effects take place in the markets. So this is the key difference. We now expect our regulators to be forward-looking. The new Digital Markets Competition and Consumer Act requires, as a first step, the CMA in its specific dedicated unit, which is called the Digital Markets Unit. We'll hear a lot about it in the future. So the new act requires the Digital Markets Unit within the CMA to make an assessment of whether or not a firm has quote unquote, strategic market status in respect of a digital activity. Stay on that slide. We'll move shortly, but not just yet. So what is a strategic market status in respect of a digital activity? A strategic market status designation is triggered for those firms that have four things. One, a link to the UK, meaning that either consumers are based in the UK or the firm is based in the UK, a link of some sort to the UK. Two, a global turnover in excess of £25 billion for a given period. It could be a financial year. £25 billion. Three, substantial and entrenched market power. Four, a position of strategic significance in respect of a digital activity. So the first job the CMA will have is look around and decide which firms operating in the UK market have strategic market status with these four components. Once it has decided, it designates that firm as having a strategic market status. That designation lasts for 5 years. It's not forever. It will be revised at the end of 5 years. And once a firm has been designated as having a strategic market status, then all the Act applies. Then the so-called competition regime applies. So essentially, we can see that this new competition regime that the CMA is asked to implement is really likely to focus only on the hyperscalers. But it is interesting in the way other market participants will be asked to contribute to the CMA work. So I think we can move to the next slide now. Okay, next again. This is the process. I'll give you a few minutes to read through it. It's not particularly exciting, but it's just to say that it is a complex process. It does involve several steps in which the firm is given the possibility to make representation, say, oh, no, we do not have strategic market status because, but also the CMA is consulting and inviting key stakeholders to present their views. So this is an interesting process whereby, for example, smaller players, startups, consumers, suppliers are all asked to give their view as to whether or not a certain firm has or has not strategic market status. So those four elements will not be plucked out of thin air. So let's go back. Remember the four elements. Okay, turnover is easy to assess. But entrenched market power, it's hard. How do you assess that if you don't speak to the people who are under the effect of that entrenched market power? So bearing in mind that the process will be a long and consultative process involving all stakeholders, we can look at the way the CMA is going to interpret all these key terms. So the CMA will interpret market power as the situation where an undertaking does not face effective competitive pressures and customers have poor alternative to its offerings. So you can see how the CMA is going to talk to consumer associations, individuals that are at the buying end of the market. Market power can also arise when customers maybe have good alternatives are available, but consumers, for one reason or another, face barriers to switching and shopping around. Again, you can see how the CMA is going to ask questions of the market. How will the CMA interpret substantial? How do you know if there's a substantial market power? Well, it's going to look at number of consumers or number of transactions or the extent of time spent using the firm's product or services. Maybe there are no transactions, but there's just time spent on it. So the CMA will interpret substantial in a very flexible manner. And when it comes to entrenched, how will the CMA look at whether or not the power is entrenched? It will consider it in a forward-looking way. It will ask itself, is this market power likely to be competed away over a 5-year period? And that's a forward-looking question. So you can see how the thinking changes here. We're not just looking at short-term price competitiveness. We're looking at longer, medium and longer term ability of new entrants to serve that market, as well as the incumbent. So the CMA will consider a firm to have a position of strategic significance, the other fourth element, if a significant number of other firms are going to make use of the digital activity for which we're discussing strategic market power when they're carrying out their own business. So you see that if a lot depends, so we're looking at platform economy here, aren't we? If we're looking at a lot of businesses depending on that single digital activity for which we're discussing strategic market power, then we're looking at a likely position of strategic significance. If that firm, that incumbent position means that it can determine or substantially influence the way in which other firms conduct themselves in respect of that digital activity by setting standards, by moderating content, by deciding the application of regulatory frameworks, then we have undoubtedly strategic significance. So the process is not going to take us by surprise. We are going to be notified, the firm is going to be notified. But once a firm, let's call it monopolist for short, has been designated as having strategic market power, then what? Well, then the CMA assesses if having a strategic market significance means that consumers could be exploited or fair competition could be undermined. So you could, in theory, hypothetically, be a firm with strategic market significance, but not exploit consumers and not undermine fair competition, in theory. So it has to designate, and then once it has designated, it has to examine if there are adverse effects on competition. And you have an adverse effect on competition if any factor relating to that digital activity means that competition is either prevented, restricted, or distorted. It could be conduct due to the conduct of one or more firms or due to structural features of a market. And then the CMA can act. It can impose directly on firms conduct requirements or pro-competition interventions without going through a court of law. So it can talk directly to the chief executive officer of that firm and impose a conduct requirement. So before we move to the next slide, let me tell you what conduct requirements have to look like. They have to abide by 3 key policy objectives. Conduct requirements that the CMA can impose on firms have to pursue a fair dealing policy objective, fair dealing to consumers, open choices, trust and transparency. So we can see that, and we can move slide, we can see that the conduct requirements has to follow key principles, and just like the designation of strategic market status has a process where there will be consultation, opportunity to hear views, opportunity for a firm to respond. So you can look at the principles very quickly, but essentially it's fair dealing, open choices, trust and transparency. The next slide will give you an overview of the process. Again, it's a consultative process. There you go. Thank you. Okay. Now, we said once a firm with strategic market status has been deemed to have an adverse effect on competition, I said the CMA can impose conduct requirements. It can also impose pro-competition interventions. And these have to abide by three policy objectives. Either they are remedying, or they're mitigating, or they're preventing adverse effects. So maybe sometimes adverse effects on competition cannot be avoided entirely, but they can be mitigated, or they can be remedied. There can be a remedy to it, a countervailing solution. So pro-competition intervention, let's have an example, can be behavioral, relating to a firm's conduct, or structural. A behavioral could be, for example, request for a firm to make its services interoperable with a competitor. That is the power the CMA has. It can say, right, from now on, this has to have an open API, or this has to be interoperable with competition. It can also impose pro-competition intervention of a structural kind. And an example of a structural intervention is, for example, the request to divest a part of a business. You have strategic market status. I demand that you divest. You split up. Sometimes it could simply issue recommendations because the problem arises not from a structural or behavioral sort of element from the firm's side, but it's in the market because other policy and other regulation are having an adverse market effect. So sometimes the role of a CMA will be that of looking at sector-specific regulations, note that they're having an adverse effect on competition, and make recommendation to other public bodies to say, okay, guys, you need to roll back the regulation because it's affecting the competitiveness of the UK market. So that is also a power that the CMA could have. So I think we have the pro-competition intervention process. Again, next slide, a series of blue dots. Again, it's a consultative process, it's subject to a time limit, and it involves a number of stakeholders. One thing to notice is if you want, the wide-ranging, non-specific list of measures that the CMA can impose on firms. And that is interesting in its own right. The other interesting thing is noted the strict time limits. This is an innovation in itself, because in traditional antitrust law and policy, investigation could take years. But with the new act, there are strict timescales within which the CMA has to make a decision and come to a conclusion. Merger control, and then we're almost finished. If a strategic market status firm with a UK connection intends to merge or acquire another firm, and the deal is worth £25 million or more, which is really peanuts today, £25 million, reporting of this merger is mandatory before the completion. Reporting of the intention to merge. Reporting of the intention to merge. So again, it's a forward-looking regime. Okay, let me take a sip of water. Lastly, and this is the most exciting part for me, the CMA is granted by the new Act powers to gather information. These are statutory information gathering powers to obtain evidence from market participants that can assist the CMA in its functions. And hear me out. The CMA has the power to require information from a firm. No big deal. The power to interview key individuals. Getting warmer. The power to enter premises. Let that sink in. The power to enter premises and presumably make a copies of all the hard drives. The power to appoint or request the firm with a strategic market status that the firm appoint a skilled person to provide a report about a particular matter. So it can either appoint a skilled person to provide a report or impose on the firm that they appoint an independent expert to write a market report. So information gathering powers by the CMA with the new act are no joke. Interestingly, the CMA is also granted a so-called set of testing and trialing powers. So these are powers by which it can require the strategic market status firm to obtain information or generate information or carry out demonstrations and tests. An example could be a demonstration of how an algorithm operates, or testing a modifying version of the algorithm and reporting on the outcomes to the CMA. So you can see how the CMA really has the power to ask strategic market status firms to open up to the CMA in the first instance and play with testing hypotheses for market effects. They will not be able to hide behind proprietary technology protection. Now, of course, a strategic market status firm must demonstrate compliance with any competition measures which has been subject to. It must compile and submit periodic reports to the CMA and a summary version to other market participants. So we'll always know if a large technology monopolist has been sort of instructed with certain competition measures. We'll always know what they are. We'll have a summary version. Everybody else will have it. It will be public. So periodic reports to the CMA of how it's complying and a summary version to all other markets participants. A strategic market status will have to appoint a nominated officer responsible for monitoring this compliance with the competition regime imposed by the CMA, cooperate with the CMA at all times. The CMA can impose penalties if it believes that nominated officers are responsible for the firm's failure to comply. So you can see why the nominated officer is a tricky role, but it has to prove that it has done everything possible to inform the firm of the obligation to comply with the competition regime. Ultimately, however, it's up to the directors of a firm to comply or not. And the CMA can also issue competition disqualification orders in relation to one or more directors. Competition disqualification orders. Last but not least, and really we're closing here, the fines it can impose can go up to 10% of worldwide turnover, not profit, 10% of worldwide turnover for failure to comply with the competition regime it imposed. So I think I am very excited about the new powers of the CMA. I hope by this time you're excited as well. We're going to follow closely this space. And you'll see that there's a lot of room for IT professionals and BCS members in particular to be part of this process. I think the next few slides really are just question slides. I think we can open the floor to questions. Thank you for listening.
Emmanuel, do we have anything on the chat and we have questions?
I'm looking through and I haven't got any particular question in relation to the talk. So we'll use this opportunity to open the floor for anyone who has any question to ask about Chiara's beautiful talk.
So, Emmanuel, are you excited about competition law?
Chiara,
Not yet.
Chiara, that 25 million you mentioned, is that index linked in any way?
Say that again.
Is that 25 million you mentioned, market share, is it index linked?
Pass. I suppose it is. Pass. Yes, it will be. It will be. It will go up with time.
It just seems quite a low figure to me.
Well, that is precisely the point. The point is that if you look at what's happened, for example, with Amazon, they've been making small acquisitions, and they've been making acquisitions in neighboring areas. They've not made acquisitions that attracted the attention of antitrust because they were not in the same market. So antitrust regulators are, well, you know, it's not going to create a monopoly. It's in books. It's buying home speakers. What's the deal? They did not see the pattern of small acquisitions around related sort of products and services that slowly build up a picture that made Amazon the ecosystem it is. The ecosystem where some products cross-subsidize other products. And in any event, you find it very, very hard to come out of the Amazon ecosystem. The so-called defensive moat, or the so-called consolidation strategy, for many of these hyperscalers has been built through making small acquisitions over time in neighboring products, in neighboring services. Does that answer your question?
It does indeed.
And in fact, you can say that even the CMA has been caught in this, and the only time they really paid attention to Microsoft is when he bought Activision or tried to buy Activision. And that was a big, big deal, but it hasn't batted an eyelid when smaller acquisitions were being made. And it certainly wasn't focusing on the fact that smaller acquisitions were really about acquiring patents, were acquiring talents. It was so-called the strategy of acqui-hiring, isn't it? And also simply acquiring a challenger before it could even pose a threat to them. Yes, I think that's really the big change now. Any acquisition, no matter how small, will have to be notified. Well, you know, a little threshold.
Okay, thank you. I also want to find out, you know, you said when companies or technology companies feel the antitrust laws, they are imposed some percentage, 10% of their worldwide turnover.
Yeah.
So can you give us more information on how this is enforced? Assuming a company decides not to pay it, what will be the consequences? Can they be shut from operating, or how are they enforced through the legal means?
This is another talk in itself. So I won't go into that because, one, I'm not an expert, not yet. Two, I know that there will, I mean, when companies are faced with such competition fines, the legal battle is to the mat. It really is something that can be protracted and prolonged. But essentially, at that point, if a company refuses to pay, it will go through the courts. And yes, breach a court order. Absolutely. There's no way you can operate in a market when you're in breach of a court order.
So do you mean the CMA has?
You can go all the levels of appeals, but you can't. After that, you can't keep operating.
Okay, so do you mean they have the powers of court, the CMA, or one has to go to court to get that powers? to be able
So
to?
the CMA has the power to impose remedies, pro-competition measures or conduct requirements without going to courts, and also the power to fine without going to courts. Of course, if then a firm is in breach of his obligations to comply with the anti-competition regime of the CMA, then we go to court. But it's what the novelty here is that it doesn't have to go to court first in order to even make a demand, for example, that a company splits one part of its operations from the rest, or that it uses data in a different way. It can directly impose that requirement. That's a novelty here.
Okay, thank you very much. And we have a question from Ashok in the chat. He is asking, are these regulations going to apply globally? Every country will try to attract large tech companies to create jobs and earn taxes, and will have local regulation that will override global regulations.
Okay, this is a very, 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 very interesting question. Remember I said the first key element for a company to be designated as having strategic market status is that it has a UK link. And that tends to be the case for most technology regulation. Either the consumers, the end users are in the UK, the suppliers are in the UK, offices of the firm are in the UK, one way or the other, there has to be a UK connection. So very simply put, if a large hyperscaler wants to do business in the UK, then this act applies, and the CMA jurisdiction kicks in. It's there. You have to be mindful that the European Union has done a very similar, sort of passed a very similar act. It's called the Digital Markets Act. And it has also passed the Digital Services Act that jointly cover more or less the same matter as the Digital Markets, Competition and Consumers Act of the UK. So Europe and the UK are, broadly speaking, aligned on this antitrust philosophy and new antitrust efforts. And so it's very unlikely that a large hyperscaler can play off the UK against the EU. Of course, there are jurisdictions that are not in Europe that may have a different approach to antitrust, but they are unlikely to be large and interesting markets as the EU, the UK, and to a certain extent the US. The US is the only case that probably is worth watching and see the direction of travel for. We can certainly anticipate a change of tune with the new administration, but ultimately the equation will be, how do you impose requirements on these firms with a technology monopoly that does not make these markets rigid, that does not completely impede to new entrants the chance, the opportunity to contest the incumbents on at least a few services or a few products. So unless the hyperscalers are interested in leaving the UK and the EU market entirely, which is an interesting option, they'll have to comply. So Ashok, I hope I have addressed your question, but please come back to me if I haven't.
Yeah, yes, you have. But the other question I have is, can an individual take legal action against one of these companies, especially if a minor has been harmed?
Especially if, say the last part of the question again, especially if?
if a minor has been harmed.
A young person. Okay. The legal tool for young consumers is really not this one. It's the, in Europe, it would be the Digital Services Act, and in the UK will be the Online Safety Act. That's the legal tool you need when content is harmful to young people. And that could be another talk, but it's not this one. And that sort of legal regime for the Online Safety Act regime, it's really the whole safety and trusty sort of conversation there, where you flag content and a platform provider has an obligation to take it down immediately. You will see that this is already happening in the EU and to a certain extent in the UK. So there's now an obligation to have a process for taking down content that has been flagged as harmful to young people. But as I said, it's a different legal instrument and it's a slightly different conversation. It's the power of digital firms over connected consumers, rather than consumers of content online, rather than market participants. So it's looking at individuals as having online lives, and whether or not these online lives are safe on the principle that what's illegal offline should be illegal online as well. But the discussion we've had today is really about market entry. How hard is it to enter a market when one of these hyperscalers dominates it? How hard is it to break the monopoly? And the key term in European law is contestability of markets. And in the UK, we're talking about adverse market effect or imperfect competition. So yeah, no, we have that. That's also covered. It's a different law.
Do you think this gives an advantage to UK companies at all, or at least be on same par as large US companies?
Does this act give, well, if the antitrust, the new antitrust sort of policy and thinking is enforced in a very energetic, let's say robust manner by the CMA, the Competition Markets Authority, in theory, we should see a much more vibrant market, one where startups don't have to hope to be buyed. You know, the only strategy a startup has today is I'll grow to the point where I'm interesting enough to be bought by Google or to be bought by Amazon or to be bought by Apple. This is not the thinking of a perfectly contestable, a perfectly functioning market. You should have the hope to challenge Google, Amazon and Apple on the key products they offer, not the hope to be buying. So yes, if the CMA has a very energetic approach, we'll see startups flourish and grow to medium and large size enterprises. This is the dream, isn't it? This is the hope.
Yes. Thank you. Thanks very much, Sheila.
My pleasure.
Emmanuel, I think we should wrap this up now.
Yeah, that's right. Yeah. Thank you so much for all the questions. And we also want to thank Sierra for such an educative and insightful talk.